Welcome to the latest episode of Called to the Bar, International Law Over Drinks. I'm your host, Associate Professor Imogen Saunders from the ANU Law School. Today, we're returning to our series of what everyone gets wrong about classic international law cases. I'm joined by Associate Professor Tamsin Paige of Deakin University to discuss the famous case involving Hungary, Slovakia, and a hydroelectric dam on the Danube River, the Gabčíkovo-Nagymaros Project case. But before we begin, I remind everyone that in these informal conversations, we are, as always, speaking off the cuff and without the benefit of footnotes. And nothing we say should be taken to have been thoroughly peer-reviewed. Now, before we get down to business, our traditional first question: I am drinking boring water, but Tamsin, you are always reliable for having a more exciting drink. What's your drink today?
So it's mid-afternoon. It's still coffee time. It's not past 4 p.m, so I'm still allowed to have coffee. So I have a very nice coffee, again, Patio Coffee's Annabelle blend that I've ground the beans myself to make what I would call, because I used to live in the US, a batch of filter coffee, but hipsters in Australia would call a batch brew. You decide which one you want to go with for how you name it. But because it's important to stay hydrated, I also have some sparkling mineral water.
Very nice. I like the 4 o'clock cutoff. I think my coffee cutoff's a bit earlier these days, sadly.
Oh, that hurts. 4 is my hard cutoff of no caffeine.
Okay, well, on to our case. And before we get into the analysis, I want to preemptively apologise for my pronunciation. I think the right way is Gabčíkovo-Nagymaros, but this well could be incorrect. Tamsin, what's the background of this case?
Okay, so this case, as we know, was about joint hydroelectric scheme on the Danube was commenced via treaty on 16 September in 1977 between Czechoslovakia and Hungary. The project was set to be a joint venture, equally funded and jointly owned between the two states. The treaty set up dispute settlement to be done by government delegates, and if they can't reach agreement, then by the governments themselves. And in May 1989, Hungary suspended work on the project due to public concerns about the project generally, and then unilaterally abandoned the project in 1989, in October of 1989 specifically. During the negotiations about what to do with this as per the treaty, Czechoslovakia developed a number of alternative potential solutions should Hungary not resume their works. And in July 1991, they settled on what they called Variant C and began work on Variant C in November 1991. There was a failure in negotiations which resulted in Hungary unilaterally terminating the treaty on 25 May 1992. So on 23 October 1992, Czechoslovakia implemented Variant C, which, for those, what that did was diverted the flow of about 80 to 90% of the Danube, which was a shared river border between the two states, into Czechoslovakian territory through a series of locks and dams. So they stole the fucking Danube. They just stole the river. And the river is no longer present functionally in Hungary at this point, or as the shared border, because it's in Czechoslovakia. So on the same day that this occurred, there was an application made to the ICJ around the diversion, but it was noted that there was no ICJ jurisdiction over this. We then have, on 1 January 1993, Slovakia becoming an independent state and the successor to the Joint Development Treaty, and by virtue of becoming an independent state now in possession of the Danube.
So I might just pause you there for a sidebar. So for those who aren't aware of how state succession works in international law, when states break up or cease to be, you can have what's called a successor state, and a successor state will inherit the rights and also the obligations of the state that existed before it, which is why we have Russia with a UN Security Council seat, not the USSR, which is why we have this case, which is between Hungary and Slovakia when you look at the title rather than Czechoslovakia.
Yes, and as a minor note, Russia is technically the continuing state rather than the successor state to the USSR, which is an important one because
Yes.
we've dealt with that, though, in a previous episode on the Security Council. However, so after this has happened, on 7 April 1993, there's a special agreement to give between Hungary and Slovakia to give the ICJ jurisdiction over the dispute. Later in 1993, there's a failure for parties to agree to temporary measures, and the dispute goes forth into the case. So there's the nutshell of the facts of what we're dealing with here.
To be summed up in, they stole the river.
They stole the fucking Danube. Just stole a river. It is grand theft waterway.
Grand theft waterway. I have to say, for some reason, variant C also always sounds to me like some particularly nasty pesticide. And which is what I actually thought this case was about for a while before I actually read it. And then realized, no, variant C is not a pesticide. Variant C is diverting a river from its natural course. But I think maybe that confusion in my mind now, in my defense, this is back at law school when I just heard of the case. And I think some of the confusion in my mind about that was actually because this case is described as one of the first truly international environmental law cases that the ICJ ever decided. And it's widely cited as an environmental law case. And we see, and we'll talk about this, I think, a bit later in the podcast, we're seeing more and more environmental law cases before the court. And this is seen as one of the first, if not the first one. Tamsin, what's your reaction to that characterization of the case?
Mostly, I think that characterization is not inherently wrong, but incredibly shallow and misunderstanding of the nature of the case itself.
Mm-hmm.
So that understanding of it being the environmental law case comes from the subject matter. It's a hydroelectric dam scheme. It's a river that's been stolen. That's environmental. And it also comes from a fairly minor argument that was put before the court by Hungary on the role of the precautionary principle in their termination, in all of their different justifications for why they weren't in the wrong here. They tried to argue very briefly that the precautionary principle was an obligation erga omnes, and therefore created an impossibility of performance of the treaty because they had to follow the precautionary principle and thus couldn't complete the treaty, which the court said no to really quickly. They occupied like 3 paragraphs of the judgment saying no. That doesn't fly. There is no precautionary principle in international law. And remembering this, the judgment was handed down in 97. So this is not necessarily reflective of the status of precautionary principle now, but this was just 5 years after the Rio Declaration where the precautionary principle first came out. So it was a big deal to see it being argued before the ICJ from environmental lawyers. But that kind of focus on the subject matter and the very small and very promptly rejected argument on the precautionary principle is what gets this case labeled to be an environmental law case when it's really not. It's a breach of treaty case, and it is a judicial masterclass on defenses of international law.
Mm-hmm.
So
before I ask you more about that, let's just talk a little bit about the precautionary principle. Because as you said, this is, maybe not the situation now, but my understanding of the precautionary principle, because it comes up in international environmental law, but it also comes up a bit in international health law and trade law, actually, when you're looking at risks of things. It's a principle that deals with unknown or uncertain risks in the future. And the idea is that when you don't know for sure what the effect of something will be, but you have a pretty good idea it's going to be bad, then you should be cautious and take care to try and divert that future harm, even if you can't prove for sure that it's definitely going to happen. Is that your understanding?
That's my understanding, yeah. It's essentially saying, well, as you said, where there is an uncertainty about the future, but enough knowledge to say this is probably going to be bad, you scale back your responses to get more information to better assess it.
Yeah.
And the reason the court rejected this as a, emerging custom, etc., And they did that, for those who are wondering, in paragraphs 111 to 114. The court had already noted that the treaty itself already had scope to amend the project in relation to new understandings of environmental sciences. So in this course of this treaty, the precautionary principle didn't matter because the treaty had already factored in amendment clauses that mirrored the precautionary principle, but were written in, the language of the 1977 original treaty. So it kind of was irrelevant to the actual case. So yeah, it's not that it's not an environmental law case. It's just that that's selling it short. Having it as an environmental law case actually discards the meat of the judgment, which, as I said, it's a judicial masterclass in both tone of writing and defenses of international law for breaches.
So which one would you like to talk about first? I'm actually fascinated by the tone of writing point.
I think we pick up on that after we go through the defenses, mostly because the tone of writing will make more sense when we go through the defenses.
Okay, so what does the case tell us about defenses?
So in terms of defenses, raised in the case were the defense of necessity, the defense of countermeasures, the defense of fundamental change of circumstances. There was an argument put around automatic adoption of treaties by successor states to say that Slovakia had no standing. And there was also a claim for material breach, for termination due to material breach. And as a small aside, this was a very early adoption of the draft Articles of State Responsibility being accepted as law for the purpose of this dispute as to the understanding of what constituted state responsibility. So both parties accepted that they would use the draft articles as the law for this dispute for state responsibility matters. So where should I start?
I mean, what we're talking about defenses here is what the state articles talk about as circumstances precluding wrongfulness, right?
Yes. Yeah.
So the idea is all these things in international law, it's not saying that a breach didn't occur, but it's saying that it occurred in circumstances, which means it wasn't actually wrongful.
Yes. Yes. And this is, I said that you could see the number of different arguments that were raised by both sides.
Yeah.
Around why what they did was not wrong under international law, even though it was a breach.
Yeah.
And so, as I said, it's a judicial masterclass in addressing all of these. So, should we start with necessity?
That's exactly
given your love of the Caroline incident.
Exactly. We've come from Doug and I talked about necessity with the Caroline. So let's talk about necessity.
And noting when I listened to that, I messaged you to say I actually kind of only referenced the Caroline as a footnote before moving on to this case to talk about necessity. So Hungary claimed that their breach of the treaty was done due to necessity around environmental harm. And the court made a few observations here. And the first observation they made, that the minute that Hungary invoked this defense, they were accepting that they had engaged in a breach of international law that attracted state responsibility. That was so by virtue of claiming necessity, they first pointed out that if they could not demonstrate necessity, then there was wrongfulness attracting state responsibility. And that was one of the consequences of the argument. They then spent a good 10 paragraphs going through in detail the requirements of gravity of the threat faced and the imminence of the threat faced, and unpacking all of those different aspects, those two twin joined aspects for necessity to be made out to demonstrate both, how the requirements of a necessity defense at international law, before coming to the conclusion that the risk of environmental harm didn't meet the gravity threshold, but it also didn't meet the imminence threshold. So therefore, the defense of necessity could not be made out by Hungary. But it's if you go through those paragraphs 49 to 59 of the judgment, there is this very, very accessible unpacking of every element of necessity with a judicial history of the development of necessity as precluding wrongfulness under international law, which is why I go to this case rather than the Caroline incident for discussing necessity when I'm teaching it, is that this is just so succinct and easily referenceable as to the elements, because they unpack both the gravity requirement and the imminence requirement in detail with a lot of precision.
And it's interesting, isn't it? Because I'm looking at the paragraphs too. But as you said, it's the first sort of real use of the draft articles on state responsibility. And, they set out Article 33, which is the state of necessity article, and they set that out in full in the judgment and then go through it. One of the things, this is a sort of, I guess, another sidebar question, but one of the things I struggle with sometimes teaching international law is the contradictions in what we say about sources and then what is treated as a binding rule of international law, even though it's not, in practice by judgments. And to me, the Articles of State Responsibility are partly an example of this because, of course, they were drafted by the International Law Commission. They are at best Article 38(1)(d) in the statute of the ICJ. They rely on state practice, yes, and you look at the commentary to the articles, and certainly the ILC uses state practice where it can to back it up. But when you look at the way the court uses them here, they don't rely on the state practice.
No, they don't at all.
They just use the articles as a shortcut at this point.
And I think that this is actually a wonderful moment, not on the sources of international law, but the basis of international law. Because what's really important is the ICJ sets out that both parties have consented to using the draft articles. And international law is a legal system of sovereign equality and consent, law by consent. So it's actually a wonderful moment to way of pointing that out when we're teaching students is we have these here and they don't fit anywhere except for maybe 38(1)(d) in the hierarchy of sources, but both states have consented that this is how they're going to use the draft articles for the sake of clarity in the dispute, which means that suddenly they gain effectively treaty status for the purpose of this dispute.
Yeah, which is really fascinating. And I guess the consequence of that, though, is, as you say, the court is very careful to say the parties have agreed for this dispute. But then this case gets relied upon for Article 33 being customary.
Exactly. And so it becomes this iterative building of sources of law, because you also have no one that I'm aware of standing as a persistent objector to the implementation of using this case and other things like it as Article 33 being considered customary law going forward because of this. So yeah, this is one of the quirks, of the fascinating quirks of international law, and why I love international law is it sits in these grey zones where everything's muddy and messy and kind of you work it out by degrees as you go.
Yeah, absolutely. It's so fascinating. And I guess, if you think about a domestic law analogy, in some ways in domestic law, you don't get to choose the law. The law is what it is. But there are avenues of, private international law. Certainly we can do choice of forum, which effectively means you're choosing the law. So it does happen in other venues.
You can still do that in domestic law in some senses, at least in federations like Australia, where you can choose which state has jurisdiction over a dispute in contract, can't you?
Yeah, no, absolutely. You're absolutely right. So there are analogies, you can't get out of criminal law, for example, but in civil law domestically, there is some flexibility, but not to the same degree.
Definitely not to the same degree, but that's because domestic law operates under a myth of parliamentary sovereignty, not a myth of sovereign equality.
I love that they're both myths, which I agree with, actually. But yeah, it goes back to, I think, one of the first, episodes we did on Call to the Bar. We're talking about how we teach international law And the biggest thing that we try and get our students to understand is that it's a horizontal system, not a vertical one.
I mean, and I have argued elsewhere that even domestic law is a horizontal system for other reasons, but that's not the purpose of this episode.
It's not. So let's get back to necessity. So the court's gone through. It's looked at both gravity and the essentialness of Hungary's actions.
Yeah.
Rejected them both.
Yes, rejected them both. So necessity has not been made out, but by making a necessity argument and then failing, Hungary is now clearly on the hook for state responsibility for breach of the treaty. So the court then moves on to Slovakia's claim of variant C being a valid countermeasure. And here's where things get interesting, because again, we have a judicial masterclass on the requirements of countermeasures, which is it must be reversible and it must be proportionate to the breach. Mm-hmm. And the court agrees that this is reversible. They can just redivert the flow of the Danube back to the Danube and close off those locks and dams, therefore making it reversible. They even accept that the planning and preparation to execute variant C, the planning and preparation for the river heist, is within the scope of countermeasures. Mm-hmm. There is no breach in the planning and preparation. So Hungary could see that this was going on, and that in and of itself was fine. That was not an internationally wrongful act. However, the minute they executed variant C and engaged in the river heist, that was no longer a valid exercise of countermeasures because it was not proportionate. Taking the primary water supply of the capital city of your neighbor is not a proportionate countermeasure to them failing to fulfill a joint development treaty.
That seems like a fair argument.
It does seem like a fair argument. I have no objection to it. But again, what we have is this judicial precision of going through why. And like they don't spend long on proportionality. They spend 3 paragraphs in the judgment, paras 85 to 87, going through this question of proportionality before very quickly concluding this is not proportionate and moving on. But it's again, we have this really fantastic source on how do we determine whether countermeasures are valid right there in the judgment. Again, it takes the judgment beyond the shallowness of saying this is an environmental law matter. It's a breach of treaty matter before the court.
Yeah, and so I'm just pulling out those elements. The court says to be a valid countermeasure, this is starting in paragraph 83, it must be taken in response to a previous internationally wrongful action of another state and directed against that state. It must be the injured state must have called upon the state committing the wrongful act.
And they note that in our 84.
Yep. And then, as you say, the countermeasure must be commensurate with the injury suffered, taking into account the rights in question. And so this is where they said first 2 were fine. Third, no.
No, and they go through and say up until the moment that they actually initiated the river heist, they don't put it in those terms. That's my terms. And the reason that's my terms will be discussed later.
Okay.
So they go through and they step us through the limits of countermeasures so beautifully. It's an amazing summary, accessible summary of the law of countermeasures, much like we've got a very accessible summary of the laws regarding necessity.
And countermeasures are, notoriously fuzzy. So having a clear and succinct summary like this is incredibly useful.
Yeah, much like Jus ad bellum and IHL, that question of proportionality is so abused by states in countermeasures as it is elsewhere.
Mm-hmm. Okay, so that's necessity, countermeasures. What about fundamental change of circumstances?
Okay, so this is another argument put by the Hungarian government, arguing that because the basis of the treaty was socialist integration, that was the basis of the joint hydroelectric scheme, and the fall of the USSR and the Soviet bloc was a fundamental change of circumstances as both states had now embraced a capitalist market economy. Pretty certain that's their words. We can check it in para 95. Therefore, the treaty no longer applied because of a fundamental change of circumstances. And this is actually an interesting one because from them it probably was a pretty fundamental change in circumstances. But the court again said no. And the court said no because capitalist market economies still engage in joint economic ventures, which they held in para 103. And the political conditions that gave rise to the joint economic venture were not closely linked to the object and purpose of the treaty as a joint economic and social well-being in the hydroelectric power generation of the treaty. So the object and purpose of the treaty is still valid, and therefore there has not been a fundamental change of circumstances impacting the treaty. So basically they're saying, yes, there's been a fundamental change of circumstances, but not to a degree that the object and purpose of the treaty is impacted because capitalists still do joint ventures.
Yes, absolutely.
So, yeah, we have this, but again, we have an unpacking of how does a fundamental change of circumstances void a treaty? Well, it needs to basically undo the object and purpose of the treaty. And we have that unpacked very, very neatly by the court. And so, yeah, like it's a really good reference point for fundamental change of circumstances. And they also tied this question of fundamental change of circumstances to the precautionary principle treaty argument by saying that actually the treaty allowed for changes in economic circumstances, etc., and for adjustments on that basis. So they said the treaty already had, the original joint development treaty already had options in place to address this.
Yes. So, I mean, this is related to fundamental change of circumstance, but they also Hungary also relied upon impossibility of performance, sort of on a similar argument, right? Because they said the economic joint investment was a thing that had permanently disappeared.
Yes.
And so then they couldn't perform their, it was impossible to perform their obligation because that economic joint investment had disappeared.
Yes. And the court went, no.
Yeah.
Very succinctly, they said no.
Which is also quite funny because, you know, when you look at the case law such that it is for cases that have successfully argued these things, it is actually usually about permanent disappearance of an object, right?
Yeah.
Like an island that sinks or a river that maybe shifts.
Yes.
So, you know, if any state was doing something which actually made it impossible to continue, it might have been Hungary in this instance.
Well, quite possibly, because what Slovakia did was actually raised in Hungary's argument around termination due to material breach. And they said that the failed countermeasures, so the variant C constituted a material breach by Slovakia and therefore terminated the contract. To which the ICJ said, yes, but you unilaterally terminated the treaty first. Sorry, terminated a treaty, not terminated a contract. You unilaterally terminated the treaty first, so you can't rely upon material breach terminating a treaty that you have unilaterally terminated.
Yes, yes.
That there's not much to say there. It was just a sequence of be a bit more logical, please.
Yes.
And the last argument that Hungary raised was around Slovakia's standing, saying that they weren't the successor state to the bilateral treaty and that successor states are not automatic on bilateral treaties. And the court said yes, but no in this instance. And the no in this instance was that because the 1977 Joint Investment Treaty and Joint Development Treaty was for infrastructure development and navigation regimes contained within the river, which is inherently linked to the territorial nature of Slovakia, they became the successor state automatically because it was tied to its territorial integrity. So they said, yes, this is true that there's not an automatic successor state adoption for bilateral treaties. However, in this instance, there was, because it was tied to territorial integrity of Slovakia as the successor state. So here we have this really, I would say, judicial masterclass in necessity, countermeasures, fundamental change in circumstances, material breach, and successor state status of treaties in this judgment, which is why I say that it really frustrates me when this gets reduced to being an environmental law case. Yeah. Like, yes, it addresses environmental law stuff, but it's so much bigger and richer than this.
Yes, yes. And I realize I misspoke earlier. So, you know, it was Slovakia, as you said, who enacted Variant C, not Hungary. So Slovakia diverted the river.
Yes.
But Hungary breached the treaty first.
Yes.
Yeah.
Yes. And as to your question about the tone of the writing and why I love it, so the reason I wanted to get to this is that the tone of the writing is such that it's both very, very formally precise and proper, but if you actually read the whole judgment, there is this cadence behind it that reads to me as if they've, sat down two children and said, you can't unilaterally breach your treaty obligations, and you can't just steal the river. Go home, put the river back, and sort this out like adults. That's the tone of the judgment. And that's why I think it's one of the best pieces of judicial writing I've ever come across.
That's absolutely hilarious.
Yeah, but it's also why I wanted to go through the substance of the judgment before I kind of got to the tone question.
Yeah.
Because it really does just have this aura of exasperation from the bench over how are any of you here before us? You're both wrong. Go home and sort it out. Yes.
Which itself is really interesting, right? Because the way that ICJ judgments are normally written is that they're done on again, sort of almost consensus basis, where a draft is circulated from the judges who are in agreement, starting usually with the most junior and working up, and people add to it. And I'm just looking at the voting record. So there were various votes for the judgment here, but sort of the most were 12, 13, 14 in favour. The smallest in favour was finding B, which was 9 votes in favour. So you've obviously got some core of judges who seem to have come together and created what is actually quite a consistent tone.
Yeah.
Because that's not the case in all ICJ judgments, right? No. Sometimes you get a bit where there's a paragraph, it's like, whoa, where did that come from?
Yeah, exactly. And so it's this, as I said, it's a beautiful judgment, and it is, if you haven't read it in full, and we'll get to that later, it is well worth for any of our listeners going back and reading it. It's not a long judgment. It's only 81 pages for the primary judgment. It's not particularly long. That includes some maps and things like that, and all of the procedural nonsense that takes up like 10 pages. So it's not a particularly long judgment, but it is a beautifully written judgment and a judicial masterclass on circumstances precluding wrongfulness in international law. So, yeah. Now, Imogen, you also really like the case, and in particular, one separate opinion, don't you? Why don't you tell us about this?
I do indeed. So I love this case, but most of my time on this case is spent with the separate opinion of then Vice President Weeramantree. And that's because Weeramantree, well, let me step back. That's because I love general principles of law recognised by civilised nations, which is the third source of international law set out in Article 38 of the Statute of the Court.
As an aside, do we still actually include civilised when we say that?
It's interesting. I do. And Dina, one of our other cohorts, Dina and I have a chapter out just recently, at the end of last year, arguing that some of the movement to pretend civilised isn't there actually discredits and disputes the limiting factor that civilised had and continues to have on the source. So to go back, when this provision was introduced by the Advisory Committee of Jurists in 1919 to the statute of the then Permanent Court of International Justice, civilised meant European. essentially. Everyone knows that's what it meant at the time. It meant white European. And there's no arguing that. Really.
No, there's no arguing that. That's why I'm asking, do we still include the word civilized?
So now people say, we don't use civilized, we just mean all nation states. The problem with that, and this actually gets a bit to why I love Weeramantri's judgment so much, is when you look at the uses of general principles of law, it's not all nation states. It is still primarily a concert of Europe. It is still usually a handful of common law and civil law states. You take France, you take England, you take the US, maybe you throw in Germany, Switzerland for a bit of fun. That's usually about it. Basically,
you Eurovision the law.
You Eurovision the law. And then if you want to be really wacky and you want an African country, you go South Africa, because that's, a nice, understandable African country. And so this is one of the things that when I write about general principles of law, I argue that what you actually need is a properly global, inclusive approach to it. It's not enough to just pick a Eurovision, pick a handful of countries and say they represent the rest of the world, let's go. You've got to engage with a diversity of legal systems. And one of my arguments, and it's not just mine, Vice President Weeramantry agrees, is that diversity of legal systems includes non-state legal systems. So you don't just look at Australia, you could look at Indigenous legal systems within Australia. And so what Weeramantry did in his separate opinion is he looked at the principle of sustainable development. So this is getting very much into the sort of substantive environmental law side of it. And in looking at the principle of sustainable development, to provide evidence of it, he looked at practice of sub-Saharan Africa tribes. He looked at practice of Iran. He looked at Islamic law, so religious legal systems. He looked at practices of Incan civilizations. He looked at Pacific Island culture, Native American traditions, different African traditions, Chinese, Japanese traditions, as well as Indigenous Australian traditions. And all of that, he said, is things that we need to look at when we actually look at civilization, that these are forms of civilization. And I'll just read you a paragraph. I mean, this judgment is just filled with gems. But what he says is, by virtue of its representation of the main forms of civilization, this court constitutes a unique forum for the reflection and the revitalisation of these global legal traditions. There were principles ingrained in these civilizations as well as embodied in their legal systems. For legal systems include not merely written legal systems, but traditional legal systems as well, which modern researchers have shown to be no less legal systems than their written cousins, and in some respects, even more sophisticated and finely tuned than the latter. And I think this is so important because he's basically flipping that civilized on its head, right? The civilized as it was used to exclude those legal systems. And it was used to say, the Indian religious legal system was not civilized. There's a famous Privy Council one saying, well, we can't take that into account. It's not civilized. It mixes conceptions of morality. We're just going to look at the English law imposed above. And, the same thing, Andrew Light has done a lot of work on this with Islamic law and investment treaties. Again, the rejection of Islamic law as non-civilized would just look at that veneer of colonial law that's been imposed. And what Weeramantry says is actually, no, if you're going to be serious about civilizations, you have to look down and you have to get below that veneer and you look at these traditional systems, these non-state systems, and you pull from them as well as the state systems to found your general principle.
That's really fantastic. And it's a really great synopsis of both why you love it as a separate opinion, given your interest in general principles, but also why it's important to not just excise the word civilization until we've actually gone through and made general principles a truly global understanding and stop saying, well, 22 European states have said, yes, that's custom, right? Which I've had this argument with people over whether or not, that would be enough to constitute the special court of aggression in Ukraine. And my answer's consistently been, no, it's not sufficient. In the same way that, talking about Palestinian statehood as a controversial matter ignores the consistent recognition of Palestinian statehood by everyone except a few European and Western states. And so, yeah, I think that's really great. And these issues are actually coming up at the moment in the ICJ climate change advisory opinion. And I dare say it probably came up in the other climate change advisory opinions as the ITLOS one that came out. And I think the Inter-American Court of Human Rights has also got one coming as well. So tell me about this.
I'm not so across the ITLOS one, but the ICJ advisory opinion, it certainly is. And so there's a couple of places this is coming out. Some of it is coming out in just the principle of sustainable development and actually the precautionary principle being relied upon by a number of states. So with the ICJ advisory opinion, and we've talked about, of course, the advisory opinion on the podcast before, but states, one of the questions for the court is what are the rights and obligations of states in respect of climate change? And, some states have some states have suggested that the entire set of laws around climate change is a lex specialis framework that is only the UN framework Convention on Climate Change and the Paris Agreement and any other agreements.
Which runs in the face of the ITLOS advisory opinion that said UNCLOS maritime pollution also means all of the CO2 emissions causing climate change.
It's probably not a surprise to you when I say those states that are arguing that are primarily oil-producing states.
Shocking. Shocked, I tell you. Shocked.
But they are in the minority, and most states recognise that it is a much more comprehensive set of laws that govern obligations in respect of climate change. And there are sort of two avenues that a lot of states are pursuing. One is, I said, just this principle of sustainable development in general. And so a lot of states are relying particularly on Wiramantri's separate opinion to make this argument. And then the other avenue that's being pursued is a separate right of the right to a clean, healthy and sustainable environment. And there's a variety of arguments about whether that right is a standalone right or whether it only exists in relation to other human rights. But again, Vice President Wiramantri's arguments here are becoming relevant again. But one of the things that I think it's really relevant, and you see this come through perhaps in a more implied fashion, but you see this come through in pleadings from a number of Pacific Island states in particular, from Vanuatu, from the Cook Islands, from the Melanesian Spearhead Group, from Tuvalu, is Wiramantri's idea of drawing on what he calls living law. Because when we look at where we're drawing the state practice for this right to a clean, healthy, sustainable environment, a lot of countries are relying on the fact that it's in national legislations, which it is. But what some of these other countries are also doing is giving examples of the living law and culture of their people, where the right to an environment and the duty to maintain that environment is actually part of the customary law, and not customary international law, but domestic customary law or custom of those people. And so I think this is another example of where, when we're looking at protection of the environment, we're looking at the right to a clean environment, a clean, healthy and sustainable environment, that we shouldn't just be looking at national legal systems, but we should be, as some of these countries have done in their evidence, dive down and look at the non-state legal systems that exist in these states and sort of embrace that plurality of legal systems that exists, and by doing so, actually have a global approach to civilization.
Which began with Wiramantri's separate opinion in this case that we both love for different reasons.
Exactly. It sure did. But I guess to sum up then, what we've said is this case is a masterclass, as you said, Tamsin, on defences. It is a fantastic example of an international court that is frustrated with two of its naughty children. But it's also a great example of how influential separate opinions and dissenting opinions can be.
And look, as an Australian lawyer, you and I both know the importance of dissenting opinions, because you haven't gone to law school in Australia unless you automatically follow the words Justice Kirby with "in dissent."
Absolutely, the great dissenter. And I think that's a really interesting thing, when we talk about international court of justice cases, it's the same for, as you say, Australian domestic law cases, but there are some cases where sometimes the dissent or the separate opinion is just as valuable, if not sometimes more so, than the main judgment of the court.
Yeah, it is. It's really important. And as I was alluding to earlier, there are reasons why I love this case beyond the fact that it's a judicial masterclass. So I first encountered this case in undergrad international law. So I was at UTS, and Stan Palasis, I have no idea where he is these days, but Stan Palasis was teaching me international law, and this case showed up in the week on international environmental law, and I had been assigned the case to do my in-class oral presentation on international environmental law and the precautionary principle. And I didn't really understand the case from all the extracts we had in the textbook. So I went and read the judgment, and I was like, holy crap sacks, this is what's going on? They stole a river? What? And this is how I fell in love with international law. I'm like, holy shit, this is really cool and interesting. They stole a river. Like, it just blew my mind. And that's where my love affair with international law started. So moving on to my first year in my MPhil at the ANU, where I was teaching undergraduate international law for Professor Don Rothwell, although I will note that myself and a number of his other grad students referred to him not to his face because we're not certain how he'd take it as Don Baby. He was known as Don Baby amongst his grad students. I have no idea if he knows that or how he'd respond to that, but that's how we referred to him. Affectionately.
Affectionately.
Yeah.
So we have a supervisor in common, Tamsin, because Don was my PhD supervisor.
There you go. He was one of my MPhil supervisors. There you go.
I have never referred to him as Don Baby, and I'm not sure I'll tell him either.
So this came from drinks with some of his former doctoral students at Sydney University, and that's where it all came to be. But that's a whole other story that we could explore at another time. And hopefully he if he listens to the podcast, he hears it with the affection in which it was used.
In which we mean it.
And so he'd assigned the case for defenses. And that really made me kind of then grapple with the case in the depth that I've discussed it now, is doing that. But what I also then encountered was students, like I did initially when I was preparing for my presentation before I then went and read the whole case, not grasping the enormity of what the case was about because they only read extracts. And so it became evident to me that everyone who talks about this case as a pure environmental law case is reading extracts. They're not reading the whole judgment. And thus, this is my personal bugbear, as we put it, with this case, is people read extracts because there are so many good, pithy extracts, as you say, even from these separate opinions, that people don't look at the entirety of the case and get that enormous context and that judicial tone of writing that you just don't grasp from the extracts in the same way as if you read the whole case. So this is why it's, first of all, this is where my love affair with international law began, but it's also where my frustration at people not reading whole cases to understand the context really came to bear, because they were missing the fact that Slovakia stole the fucking river. And when you put it in those terms, this is why I call it the river heist or stealing the river. When you put it in those terms to undergrads who haven't read the case, like, what do you mean? What do you mean they stole a river? And it blows their mind because they haven't actually read through the whole case. They've just read extracts in the textbook. And it's such an interesting case, and it's such a beautifully written judgment that people should engage with the whole case, and not just the occasional extract.
Not just the extracts. This is where Doug and I got to at the end of our Caroline episode as well. It's about context. And I think, our series of misunderstood or misemphasized, I guess in this case, cases is often about that the case has been taken out of isolation from its context. And because of that, it's not properly understood for what it is, whether it's being used for the wrong doctrine or it's being an emphasis put on it that probably isn't the actual emphasis of the case, or simply the gravity of the conduct isn't recognised. It's all about going back to that context.
Yeah, and as a knight, I owe a lot to Don Rothwell for assigning it as the second week of the undergrad international law on defences at international law, because it actually forced me to read it in that light and moving beyond the environmental law precautionary principle light it was taught to me in. And like, that's not a criticism of Stan. Like, I owe a lot to him. He was an amazing teacher. He also taught me law of the sea, which is, you know, was where I started my research career there. So like, that's not a criticism of his teaching, but it's a case of there's so much more there than he taught it. But that's also because he was dealing with environmental law in his research, so that was his focus. But yeah, it's just so much more going on with this case than people give it credit for.
And that's, you know, it's also, I'm sure, and we talked about this, we talked about teaching international law, is we're always battling the fact that we have 12 weeks to get across entire fields.
I only have 11.
Well, so we take, you know, we have to teach it in a condensed version.
Yeah, and we make decisions.
Yeah. But I think this is a really good reminder for anyone out there, students, us, read the case, find out that there was actually a river heist.
Yeah, like seriously, that you couldn't put that into a Bond movie.
No. They stole the fucking river.
Yep, they just stole the fucking river.
Tamsin, it's been a delight. Thank you very much.
Thank you.
Till next time.
Bye-bye.